Good morning and congratulations and welcome to Student Teaching. This screencast, Legal Issues and Responsibilities for Student Teachers, is a conversation between Bradley Bartels and Jenny Whitcomb. I'm Jenny, the Associate Dean for Teacher Education, and I've invited Bradley Bartels, or Brad Bartels, who is an adjunct instructor in our program. He's received his PhD from the School of Education, and he's also legal counsel for the Colorado Educational Association. What we want to do today is, so welcome, Brad.
Thank you. Nice to be here.
Really glad you're here. What we want to do is give you some general guidance with regard to student issues and teacher issues that have legal dimensions to them that you may encounter in your student teaching semester. And our goal is to set you up so that you're aware of these issues, attentive to them, and know who to consult in your building should you have need for more information if a situation arises in the course of your student teaching semester. We're going to start with student issues. One of the big worries that lots of student teachers have is how to respond to student conduct and discipline and what's sort of in your parameter. And so, Brad, do you have advice for our new candidates about student conduct and discipline?
Sure do. State law is very complicated in regard to this issue, but generally your school district is required to have a written discipline code for students. And that discipline code kind of outlines student responsibilities, teacher responsibilities, and administrative responsibilities. They're required to have this under state law. So one of the things you can do as a new student teacher is simply access your discipline code online if your school district's discipline policies are online, and just look through them. It'll only take you a couple minutes. The important one from your standpoint is, though, what kind of actions can you take as a student teacher with students who are being disruptive or handling themselves in a way in school that is affecting the education of other students? And basically, your rights as a student teacher are no different than a teacher's. That is, it is possible for you to use reasonable and appropriate physical intervention to protect students from harming themselves or others or damaging school property. That does not mean that you can use physical intervention with the student who's, say, talking back to you or maybe isn't following your directive to get in line or something of that nature. But it does help when you have students who are actually involved with interacting with each other in a way that might harm another student or themselves, or if they're vandalizing school property. You can act with reasonable and appropriate physical intervention, meaning you can restrain the student very briefly if they are engaged in those kinds of activities.
Related to this, and I think that something that students really worry about is what do they do with a habitually disruptive student? What are their responsibilities and rights in responding to those particular students?
Well, one thing that's very important to remember is that you need to document disruptive students or student misconduct in a way that you can access later if someone asks a question. School districts under state law are also required to have a policy regarding students who have been suspended 3 times in a single year. And the school does have the authority to suspend a student on an emergency basis for up to 5 days. So it's very important as a student teacher that you assist your supervising teacher in documenting and making sure that students who are being consistently disruptive, you have good records in regard to that. There are a number of reasons why students may be suspended. That includes persistent, defiant, or disruptive behavior that's been well documented, or destruction of school property, or interference with the education of others. Now that can cover a lot of ground. That can mean harassment of other students in the classroom on a consistent basis. Doing bullying may fall under this category, and you need to keep a close eye on things like that. But the bottom line is the schools actually do have the authority to suspend students, particularly ones that are consistently engaged in disruptive conduct. But it's your job to document that and basically follow up on when students are being consistently disruptive.
So I have a couple questions about documenting. What counts as good documentation? Are you obligated to share that with someone else? Where do you store documented notes? Can you give us a little bit of info on that?
Basically, that falls into 2 categories with me. I advise teachers to follow the school district's discipline ladder for students. Almost every school district has a policy in place that includes office referrals, teacher referrals, whatever it happens to be. It's very important that you use whatever documents your school district has provided for that purpose. A lot of times what happens with student teachers is student teachers feel uncomfortable disciplining students because they're just trying to really build a rapport with those students. But it's very important that you use whatever system your school or school district has in place. The other thing I recommend student teachers do is just get a cheap spiral notebook and just keep a really brief daily log on interactions with students or problems that you may be having with different students, so that if asked, you can place your finger directly on your journal and say, well, this is the last time that the student was being disruptive, and this happens quite a bit. It also is very handy to keep a journal like that just for your own growth purposes, because you're going to find after a few months that you're interacting with students a lot more readily than maybe you were when you first started. But so that's the two parts. Make sure you follow your school or school district policy regarding discipline ladders, and also keep a very brief journal.
Thanks. So do these policies around disruptive students apply to special education students or students who are identified as special education?
They do, with some minor exceptions. One of the things that teachers or student teachers share with me on a consistent basis is many of the students they work with do have sort of consistent characteristics where they're very disruptive. It may be an emotional sort of disability, it may be a physical disability, it may be something that's diagnosed that's part of an IEP. But the bottom line is any teacher or student teacher working with SPED students is not required to basically put themselves at risk of harm simply because a student is a SPED student. Those policies apply equally to violent and disruptive special education students. And those students may be suspended if the student poses a threat to either themselves or others, in the same way that a student in a mainstream type classroom might be. Also, many SPED students these days are mainstreamed in the classroom, which makes it even more important that we follow whatever discipline policies we have.
Thanks. So one of the things, especially for secondary candidates, is understanding what you are supposed to do if you observe or suspect use of drugs and alcohol. What does the law say you need to do as a teacher?
Well, the law is without compromise in this day and age. Essentially, any student who is selling a controlled substance at any time related to any school activity, and this includes if they're off campus on a school trip, or if they're meeting somewhere off campus with another group of students. Basically, the rule is expulsion in those cases is mandatory. Student may be suspended or recommended for expulsion if they have used, sold, distributed, or been under the influence of an alcoholic beverage or other intoxicant, even if it's just an imitation. So even if you see a student carrying a baggie of oregano around, if basically they're in a situation where they are presenting that to other students as some type of drug, they also might fall under this policy. The bottom line for you as a student teacher is drugs, the answer is no in any way. If you suspect anything going on with students and drugs, you should report it right away.
And who do you report it to?
You report it to your school principal. You are not required to report it to law enforcement, and in my opinion, what you should be doing is communicating with your school administrator over this, at least in the initial stages.
And is this something that if you do suspect and report that you should also document in that spiral-bound notebook?
I think that would be a very good idea.
Okay. So something on our minds right now in light of, in particular, of recent events in Connecticut, but also reaching back to Columbine, is a teacher's responsibility to protect children's safety and how to handle the threat of weapons in the school. So tell us a little bit about teachers' responsibilities in this arena.
Well, because this is so important, essentially, school policies in regard to weapons and state law are just like drugs. Expulsion is mandatory for any student who has carried, brought, used, or possessed a dangerous weapon at school. And this would include any guns or even like a cap gun would fall under this. Any kind of compressed air weapon at all. Any kind of knife that's at least over 3.5 inches long, which is considered a blade that can cause deadly harm, or any kind of spring-loaded knives like switchblades, or any other weapon intended to be used to inflict death or serious bodily injury. This covers things like nunchucks, basically anything that can be used to carry out violent acts in a school. If the student is seen or using one of those weapons around school or on a school activity, basically they are expelled.
Okay. And if a teacher observes this, what does he or she do? If you think a child has something, even if it's an imitation firearm or a knife that is too long in a lunchbox brought in from home.
Basically, it's the same situation as drugs. You should report it immediately. Most schools have ways to immediately call the office if you see something like this going on. Many schools have school resource officers on duty in the school that can take care of these issues. What you want to stay away from, unless it's an imminent threat of serious bodily injury, is any kind of situation where you are actually restraining a student who is armed. You should report it immediately to your school administrator.
All right, thanks for that helpful advice. Related also, I think, to creating a safe classroom environment and protecting children, and youth, which is your job as a teacher, is understanding what students can say or not say in a classroom that might constitute a threat to classroom safety, and where do students' free speech rights begin and the collective responsibility to protect the classroom environment and to maintain a proper educational environment start? How do we weigh that tension?
Well, essentially, as a student teacher, this can happen for you in two different ways. The first way is when you have a bullying situation, that is, where one student is threatening another student, threatening them with some kind of harm to their person, or if that bullying or if those sort of vocal threats can somehow cause some kind of what the law calls a material and substantial disruption of school activities or an invasion of the rights of others. As with drugs and weapons, when you see something like this, you should follow the school discipline ladder. You should report it to your administrator or your supervising teacher if they're close by. These are things that you can't let go. You do need to report them. I would suggest keeping documentation on any of these things as well. Where it more often comes up, though, is in the context, for example, of a school assignment, when a student is maybe writing in a journal or writing an assignment, and in the course of doing that assignment, they express some kind of threat to another person. I hate my teacher. I'm going to kill my teacher. I hate my parents. I'm going to kill my parents. I'm going to use a knife on my student that sits next to me, or something like that. Those can certainly be construed as true threats under some circumstances, and they should not be treated as a confidential matter between you and a student. When a student makes any kind of threat, it should be reported. You're not like a physician or a psychotherapist. You have no duty to students to make sure that anything they tell you in written form is confidential. And the same is true if they're writing online or something of that nature and they make some kind of a threat to another person and it's accessed by others and it causes some kind of disruption. The bottom line for you as a student teacher is, when in doubt, report to your supervising teacher, to your school administrator. These kinds of things cannot be kept confidential. You must make sure that you take these things seriously.
And so many of you, we hope, will become involved in supporting and promoting different ways of productions or plays or newspapers that help students develop and find their voices. And we want to talk a little bit right now about what rights students have when they're engaged in school-sponsored student events with regard to speech.
Essentially, students do have First Amendment rights to free expression. However, in a school setting, that is tempered with the effects that some things like that can have. Essentially, students can write about things that are controversial. They can put on plays about controversial issues. They can make announcements in schools. They can be involved in student publications such as yearbooks. And they do have rights to free expression. However, those are tempered by the setting in which they are made. And what the law says is that those things can be regulated by school administrators, for example, as long as that regulation is reasonably related to legitimate pedagogical concerns. Now, that covers a lot of ground, and there are many criteria for that. But essentially, where it most often comes up is in age-appropriate type of expression, making sure that school-sponsored student expression doesn't cross the line and affect other maybe younger students, or it may be something that's an expression which advocates some kind of socially undesirable behavior, such as drug use, such as sexuality, such as radical political movements or things like that. Many of these things can fall into the categories that where schools may regulate them. And it's sort of a case-by-case basis. But your job as a student teacher is essentially to monitor those things. And if you have a suspicion that maybe a student in expressing themselves in some kind of publication or activity has maybe crossed over the line, again, the proper thing to do is share it with your supervising teacher, who will potentially talk to a parent or guardian. It may go to the level of disciplinary action with the school administrator. It really depends on the expression itself.
And do schools have any kind of publication codes or guidelines that are helpful for anyone who's involved in student clubs or courses that involve student expression, like newspaper, yearbook?
Well, like many things with public schools in Colorado, the law requires them to adopt certain kinds of policies providing for that. There is supposed to be no prior restraint of student expression, but again, that is tempered by the setting in which that kind of expression is made. And there are many cases where if the expression is obscene or defamatory or advocates for treasonous acts or advocates for violation of school district regulations, or if they cause some kind of substantial disruption in the school, they can be regulated by the school and by the school district. And again, my advice is the same. If you have an issue or concern with what a student is doing in a student publication, you should share it with your supervising teacher, and it may rise to the level of something that a school administrator may need to get involved with. But what we shouldn't do is just assume that students have a First Amendment right to say and do anything that they feel like doing in a school setting, because it's simply not true.
Thanks, that's very helpful advice, and we do hope that all of you consider getting involved in supporting students' voices in school and do so in respectful and appropriate ways. Let's move on to another category of student issues, and that has to do with students' Fourth Amendment rights. Can you remind us what the Fourth Amendment is?
Well, the Fourth Amendment to the United States Constitution provides in the Bill of Rights that searches and seizures shall not be carried out in an unreasonable way. And that extends to students in the school setting because students carry backpacks, students carry purses, students often drive cars, students have lockers, and a lot of issues can arise in a school setting about when it's appropriate for school authorities or law enforcement to basically carry out searches and potentially seizures of contraband material in schools.
So what are some of those circumstances in which that's appropriate?
Well, first and foremost, student teachers should be aware that in a school setting, school districts can carry out, for example, any kind of individualized search of a student if there's a reasonable suspicion that that student is committing a criminal act or is somehow violating school rules. It most often arises in the context of school locker searches, which have been upheld by the courts, or school vehicle searches, vehicles that are parked in a school parking lot, if there is some kind of a reasonable suspicion that there's something in an automobile, for example, like weapons or drugs. Those kinds of searches have been upheld in a school setting. Quite often what it comes down to, though, is what a student is carrying on them. That is, if they are carrying a weapon or if they have drugs in the school. Again, it's possible to search purses and backpacks, student clothing. There have been cases where pat-downs of students, if there's an individualized reasonable suspicion of unlawful activity, they've been upheld. The bottom line for you as a student teacher is you are not in a position where you are expected to be responsible for searching students for contraband in the school. If you feel that you have a suspicion that a student may be carrying a weapon or may be carrying drugs, you should, as with many of these, simply inform your supervising teacher and call an administrator if you have some kind of suspicion like this.
Okay, and again, I'm assuming we document this in that spiral-bound notebook.
I think that would be a good idea.
All right. We're still in that same category of student privacy and also protecting school safety, et cetera. And so what rights do students have with regard to drug testing at school?
Well, as with other areas, this is not something as a student teacher that you have to be actively and directly involved with, but it's important to realize that school districts quite often do have drug policies. They often have drug testing policies. This can take place even if there's no individualized suspicion that a student is using drugs. What the law calls a special needs doctrine is basically a balancing test where law enforcement officers and school district administrators have to consider what the nature of the privacy interest of the student is, the degree of the intrusion, and the nature and the way the testing rules work. And let me give you a couple of very brief examples. Certainly a strip search of a fifth grader when they're suspected of maybe stealing money is something that would cross over the line. That would not be permitted under the Constitution. Things like a random drug testing policy for student athletes when there is a well-documented drug use problem at the school is going to withstand a challenge. That is probably going to be considered constitutional. Many of these random drug testing policies involve, for example, urine testing at school. And again, we have to apply those criteria. But quite often students are subjected to random drug testing. So you just need to be aware of it.
And if you're a coach or your school has a policy where students have signed, particularly high school athletes have signed a policy that says they won't use alcohol or drugs during the season, for example, I'm assuming that kind of blanket signature makes it very easy for schools to be on solid ground if they want to implement random drug testing?
That is 100% accurate. In fact, that's usually the way these kinds of issues may arise for student teachers. You may be working in a physical education program. You may even have duties as sort of a volunteer coach. And these things can apply to you as a student teacher. If you have an individualized and reasonable suspicion that a student is using drugs or is under the influence of drugs, then you should report it to your supervising teacher. You should document it. And if necessary, report it to your school administrator.
Okay, thanks. We're moving on to, this is related to privacy, but a slightly different category. And this is, tell us a little bit about students' official records in the school, those cumulative educational records, and who has access to those, and what your responsibility as a teacher is to ensure that what is private remains private and what can be shared is shared.
This is a really good subject because it does come up from time to time. Under federal law, there is a lot of protection for various types of educational records of students. And you as a student teacher are expected to abide by those rules. In general, when you're dealing with educational records, that is some kind of an official record that is kept by the school or school district, that can involve testing records, it can involve curriculum issues, anything with a student's name on it is considered to be private, except for it can be disclosed to people in the schools that have a legitimate need to know those things. Those are most often school principals, whoever the person is in the school or school district that's charged with being the custodian of the records, or there may be some things in regard to school district policies. Those things have to be kept private. As a student teacher, how this most often arises and how student teachers can sometimes get in trouble is if they share those types of formal and official educational records with people outside the school. For example, other parents, other students, or things of that nature. And it doesn't create a liability problem for the student teacher, but it may create a liability problem for the school district. And so it's very important to not share students' educational records with anyone other than those persons within the school who have a need to know those things. Similarly, parents do have a right of access to their students' educational records. And if a parent is asking, for example, that you share information regarding a student's progress, while they're not school district employees, parents are definitely excluded from the kind of privacy concerns that are created by this federal law. And so those things are open to inspection by parents.
And by parent, does a step-parent, non-biological, does a grandparent or an aunt, uncle, how does the court look at the word parent?
Typically, it's fairly broad. Parents, legal guardians, that type of category would not fall under the prohibitions of federal law.
And to be clear, if you're a teacher, a student teacher, and you want to look at a student on one of your class roster's files, you have a genuine reason a legitimate educational interest, so it's okay for you to look at a student's cumulative file.
Yes, it certainly is. Particularly if you're a student teacher who is working with extraordinary needs or special education children. Sometimes things in the records can be very important as far as implementing an individual education plan. And so it's very important that student teachers have rights to those as well. During the time period that you are working as a student teacher, you're generally considered a school district employee, even though they're not paying you money.
So we're going to shift gears a little bit, but we're still talking about student issues that are associated with your responsibilities to promote a safe environment for all students in your classroom. And I want to talk a little bit, or ask Brad to tell us a little bit about issues that might arise that fall under the umbrella of sexual harassment in schools.
Well, it's an interesting issue because some of the things we've been talking about so far are protecting students from harming each other, potentially protecting yourself. But there's a lot of other kinds of bullying that takes place in the schools that you need to be concerned about. And one of the major issues in schools is basically issues surrounding sexual harassment. Sexual harassment of students, including any kind of sexual advance from one student to another, any kind of request for a sexual favor, any kind of verbal, visual, or physical conduct of a sexual nature in an educational setting is prohibited. Now, it's not a crime to sexually harass somebody, but what it does is it opens up the school district for liability it's a form of discrimination that they are allowing students to basically harass each other with sexual conduct. Interestingly enough, and the reason why this is so important, sexual harassment can occur between students, it can occur between a teacher and a student, or it might be perpetuated or by a student toward a teacher. So under Title IX, basically what happens in the schools is all of that's prohibited. There are both state and federal laws that prohibit this type of sexual harassment. Submitting to sexual conduct is explicitly or implicitly a term or condition of employment or used as a basis to make employment decisions is so-called quid pro quo sexual harassment. That means, for example, a teacher goes to a high school student and says, I'll give you an A on this test if you meet me after school somewhere because they have a romantic interest. That might be the type of sexual conduct that would be prohibited for quid pro quo sexual harassment. What's usually a little more common is sexual harassment which takes the form of sexual conduct that has the effect of interfering with an employee's work performance or does create an intimidating or offensive work environment. Now you could substitute the words in the context of the school's learning environment. The same thing is true here. If an adult, for example, a teacher in the classroom is constantly using sexual innuendo to make jokes or to make points with students, that's probably the most common situation where student teachers can get in trouble with these types of issues. It's very important that you maintain your professional boundaries. It's very important that you not treat students in the classroom like you may treat your peers, for example, in a college or graduate school setting.
Is there a likelihood that, particularly in secondary schools, that students may find that students are sexually harassing a fellow student? And then what's your affirmative responsibility as a teacher if you observe or hear that?
That's a great question because that's the other context that it arises in quite often. Like many types of student discipline, what your rights and responsibilities are in regard to this type of sexual harassment is if you observe it, you need to report it. School districts have policies regarding sexual harassment, both between teachers and between students. You need to, like many other things we've talked about, document your concerns, make sure they're reported. Don't just let it go. It's when we let bullying go that these types of problems can really seriously affect the learning environment.
So some general considerations that might guide what we need to attend to as teachers are,
Just because somebody talks about a subject that might be considered to be sexual in nature in some way does not necessarily mean that it's raising issues of sexual harassment. Whatever the type of sexual conduct it is, be it verbal, be it written, be it physical in nature, it must be unwelcome. So simply because a student is exhibiting some forms of inappropriate affection in the school does not make it sexual harassment. It has to be unwelcome. That typically happens at the secondary level quite often. Just because students are engaging in that does not necessarily mean it's sexual harassment. They probably should be advised to not do that at school, but it doesn't rise to the level that where you would need to report it necessarily here. Again, sexual conduct can be verbal or nonverbal. It may be physical, it may be written, it may be words that students are using. It might be just one very serious element of sexual conduct which rises to the level of sexual harassment, or it might be a pattern of like really small items over a long period of time. Again, sexual innuendo is a trap that student teachers often fall into because they're used to potentially communicating with their peers in that way, but it doesn't work in school and it can really cause a problem for you. Again, it can be a single instance if you become aware or see students conducting themselves, for example, physically in a way, in a sexual manner toward another student and it's clearly unwelcome. That is the kind of thing that you should immediately report and you should immediately document.
what about other issues of potential discrimination in the school setting that we should be attentive to?
Well, the same things hold true in the school as they do in the outside world, and that is that school employees cannot discriminate on the basis of race, religion, color, sex, or national origin, just as it occurs in the world of employment. Under Title IX, those types of discrimination are actually prohibited. And it doesn't mean it's a crime. It doesn't mean that if you somehow treat someone differently that you're going to be arrested. But what it does mean is that your school district may become responsible for your actions if you are discriminating on the basis of those various classifications which are membership in a protected class of persons. Where it most often comes up is qualified students with disabilities. Most of these students have individual education plans, and it's very important that those students are not denied any of the benefits of being a student in the school or any type of participation in school activity simply because of a disability. That's very important that we ensure that every student in the school has a right to their education.
And then finally, I think the last student issue that we want to touch on is your responsibilities or understanding compulsory attendance rules in Colorado.
This is a really interesting issue, and I think one of the reasons it's in here is it's so misunderstood, particularly if you're working in a secondary school. What Colorado law says is that you only have to attend school until you're 16, not 17 or 18. There is no state law that requires an 18-year-old to attend school. They do have to attend a certain number of hours each school year. That hourly limitation is very low. Anyone who is attending even on a less frequent pattern than other students may still reach this mark. Where it most comes up in regard to what you're going to be doing in the schools is you have a student who's chronically absent. And that's why this is in here. It probably is not going to cause a problem with compulsory attendance. What it does cause a problem with is students are unable to achieve if they're not there. But you should be aware of what the state law standard is.
And I think the rule of thumb here with regard to attendance is follow your school and/or district's policy for recording attendance, no matter how much a student might plead with you, particularly at the secondary level, about don't mark me down because I was only 5 minutes late, etc. So is that an accurate set of advice for our students?
Absolutely. It is very easy for students to pull at your heartstrings, particularly if you know that they're experiencing problems at home or problems with transportation, or there may be some other things going on in their life that are really kind of causing them to be in a situation where they're not attending on a regular basis. You still need to follow the rules. You still need to keep attendance. If there are consequences for the keeping of that attendance, you should not put your interest in having a positive relationship with a student over the fact that there's a reason why we have attendance rules, and that is to ensure that students have an opportunity to participate in their educational process. So you should follow the rules.
So we're wrapping up the first half of the legal issues talk, which focuses primarily on student issues. And if I can sum up, I think the big bullet points that all of you should take away from this are find out and know school policies around all of these different topics that we've raised today, in particular discipline, attendance, etc. Document any concerns that you have related to any of the issues that we've written up, and that is just a brief date and a note of what you observed or overheard. It does not need to be a long extended text. And report, if necessary, to your supervising teacher and/or building administrator if you have questions, concerns, because your primary responsibility around all of these particular student issues as a legal responsibility is to protect children and to ensure that they're in a safe, equitable, and appropriate learning environment to focus on the work that you really care about, which is kids learning. And we're going to shift now to teacher issues. We're going to shift gears now into teacher issues, and there are many different issues we could raise in this section, but what we're going to focus on is helping you build your toolbox around a highly sensitive area of teaching, and that is child abuse, and also understanding some of the boundaries with regard to your physical contact with students. And we really want to build your toolbox, and one of the biggest tools in that toolbox right now is your awareness of what the issues are, what the definitions are, and what the consequences are for crossing boundaries or failing to pay attention to kids' safety, particularly as it relates to child abuse. So I want to start off by asking Brad to help us understand some of the big picture categories around child abuse.
Well, the term child abuse covers a lot of ground, and people that like to talk about education refer to child abuse in many different contexts. For you as a student teacher, what's important to know is there are a couple different ways where issues of child abuse may affect your student teaching. The first one is if you receive a subpoena to testify. This usually happens in the kind of situation where, for example, a child's parents may be involved in a custody dispute, in a divorce, and what happens in that case is parent A is trying to get evidence that the child is better with parent A than parent B, and of course parent B is trying to do the other side of the coin, trying to show that somehow being with parent A affects the child. So what it comes down to for you is you are a witness. You are in the classroom every day with children who may be doing well or may not be doing so well, and they may want to subpoena you in or to talk to you in regard to a legal proceeding. My advice in regard to that is fairly straightforward, and I'll get to that later. The second way you can get into a child abuse case is if you witness child abuse occurring. Sometimes this may be something that you see a parent do. Sometimes it may be a little more problematic in that it may be a colleague of yours, it may be another teacher or school district employee, and you observe them treating a child in a way that you reasonably believe, constitutes child abuse. The third way you can get involved in a child abuse situation is if you yourself are being accused of either criminal child abuse or you're accused of abusing a child pursuant to the Colorado Children's Code, which is basically administered by the State Department of Social Services.
So let's talk about that first opportunity, and you sort of started to warm us up with this, but what happens if you're subpoenaed to testify in potentially a custody case or some other case involving a child? What are your obligations and what do you need to know about if you're faced with that situation, even in student teaching?
Well, the first thing is you can only testify regarding your own firsthand knowledge. That is what you see, what you hear. You are not expected to be a social worker. You are not expected to be a school psychologist. Those people are basically charged with duties of assessing where children may be. You're a good witness because you spend a lot of time with them. So if you receive a subpoena, what I would suggest is that you report it to your school administrator and then potentially just contact the person that's issuing the subpoena and asking them, what is it, why am I being subpoenaed? What information are you looking to elicit from me? Usually they're not sure and they just want to bring you in as a witness, and they listed you as a witness and subpoenaed you so you'd feel more comfortable talking to them. You are not required to talk to them, however, and your duties only extend as far as testifying regarding your firsthand perceptions.
Thanks. So you mentioned that the second way or occasion in which a teacher might need to address issues of child abuse is if they observe child abuse. Can you tell us, and this is probably one of the more likely ways that this might arise in the context of student teaching, and this is something that we've prepped you for a little bit in prior sessions going back all the way to your orientation when we've mentioned the topic of being a mandated reporter. So what happens if you observe child abuse? First, what constitutes child abuse?
And I'll talk a little bit more about the definitions, the legal definitions of child abuse later, but generally it's an act or omission, means it's something that someone did or something that someone failed to do, which somehow results in some type of physical harm or neglect of a child. And I know you've spoken in other contexts about what the indicia of abuse may be, and I've listed several of them. One of them is that you observe actual injuries to a child that are not explained by something that's going on in school. There may be signs of neglect. For example, you'll see students that consistently come to school every day wearing the same clothes, and maybe the clothes aren't in very good shape, or maybe they always seem hungry, or they're always asking if you have anything to eat, or they may exhibit some traits that indicate that somehow psychologically they are in a situation which is very abusive. If they fail to want to speak out for any reason, for example, or if they react to your speaking to them and interacting with them in a way that's very negative that really can't be explained by the context in which it's occurring. Basically, if you have a reasonable belief that a child is abused, you do have a responsibility to report it to law enforcement or social services, and you do have immunity if you make that kind of a report and it turns out that the child's not being abused for that reporting. The only thing that would stand in your way here is if you're basically reporting child abuse as a way to retaliate, for example, against a parent that may have been difficult in the context of your employment.
And I'll point out that every one of you's district will have a policy around how to report child abuse. They often have documentation, and because this is such an important topic, many of you will also be asked to participate in district-based training around mandated reporter. And it's just really important. You can't hear this message enough to really have it at your fingertips should a case arise where you need to act. So if you have a situation where you should act and don't, so you fail to act, what are some of the consequences if you fail to report a child abuse issue or suspected child abuse issue?
Well, if a child abuse has occurred and you are aware of it and don't report it, the failure to report it is actually a Class 3 misdemeanor. And while that's not a very serious crime, it can raise serious issues in regard to your career. You do have a duty to report. The interesting thing about this is, unlike many of the things we've spoken about today, your reporting duty is not satisfied by simply reporting it to a supervising teacher or to a school district administrator. Your duty is only satisfied by reporting to a law enforcement officer or the Department of Social Services. Now, many school districts have policies in regard to reporting. They will have you document this by filling out a form. They are required at that point to report to law enforcement or social services, and quite often there'll be a form that comes back to you saying this matter was reported, therefore we believe your duty is satisfied. But some school districts are smaller and some school districts don't have that policy, and so it's very important for you to know if you think a child is being abused, you must call law enforcement and report that. If you fail to do that and it turns out that the child was abused and you knew about it and didn't report it, teachers and student teachers sometimes have been charged. Don't rely on school district officials to report it. Unless you can assure yourself that it actually has been reported, you should be the one making the call.
So what happens, are you obligated if you report to law enforcement or Child Protective Services? Do you also have to report to the school administrator?
Some school district policies require a report to be made to a school district administrator. In my opinion, in addition to your reporting duties to law enforcement, it is always a good idea to report that to a school district administrator as well. In fact, I would suggest reporting it to a school district administrator first and seeing how the process works. But when in doubt, you must report to law enforcement or social services directly.
And if you ever suspect a fellow teacher or administrator in the building, these are very rare circumstances, but sometimes it happens.
Well, you have the same duty to report, even if it's a coworker or colleague or school district administrator. Obviously, this raises a lot of issues because your duty to report can conflict with your need to build a rapport with the people you work with who are actually sort of responsible for supervising you. But the bottom line is, even if it's painful, you do have a duty to report. What I always tell teachers is, when in doubt, report. If there's problems that arise at a school district level because a report has been made, then we'll deal with those. But it's very important for the safety of children and the importance of creating a good learning environment for children that we report. When in doubt, report. You must report if you see something like this, even if it's a colleague, even if it's a supervising teacher. You must report. It is a legal duty and it's very important for children.
So this is kind of a back door into this third way in which you might end up needing to deal with child abuse, and that is as an employee if you are suspected of child abuse. So help us understand this particular situation,
Well,
which we hope you never are in.
And I share that hope. This is the category of being involved in a child abuse case that teachers really don't like to talk about. It's fairly rare, but it does occur. And when it does occur, it can change your career and it can change your life. And that's why this is so important to talk about it. So before we talk about this in more detail, it's really important that you understand sort of definitionally what child abuse really is. There are many different definitions of child abuse in the law. The one that you really need to know about most is that if you intentionally or negligently cause physical harm to a child, it's a Class 1 misdemeanor. It's a fairly serious misdemeanor, and it can obviously lose you your student teaching position, and it may affect your licensure, it may affect your career. So you have to take this very seriously. Usually, physical harm means bruising, redness, some kind of laceration, something that's physically tangible. It usually as an employee, you won't get charged with child abuse if there's not some sort of physical manifestation of harm. Now, there are other definitions of child abuse which you at least need to be aware of. Number one is if you have an interaction with a student that might be considered child abuse and that student is over the age of 16, it's a lesser degree of child abuse. It is also possible to run afoul of the social services definition of child abuse, which is basically an act or omission to act which affects a child's well-being, and that can be anybody under the age of 18. So there are different definitions. What you most need to know is any kind of intentional or negligent harm to a child, particularly if there's physical manifestations of harm, probably will be charged. One thing that teachers generally don't like to talk about is they do have physical interactions with students from time to time that are certainly not meant to be abusive, but they can be misunderstood. And it's very important for you to know, and we'll touch on this later, that you cannot touch students in intimate parts of their body for sexual gratification. That is a much more serious crime. It's actually a Class 3 felony. Under certain conditions, it's a Class 2 felony, and obviously that can affect your freedom, it can change your life, and it can put your career to an end, even if it's just an allegation. So we're going to have to be very careful with that.
Well, what I'm hearing is a lot of issues around boundaries, and maybe to help us really understand the big picture point here about avoiding child abuse allegations, so never being in that situation, is really understanding what that means to keep your professional boundaries intact.
That is very perceptive because this is probably the heart of what it means to be a teacher in an age where very often teachers' actions are second guessed. There are things you can do as a student teacher, as a teacher on the front side, to not put yourself in a position where somebody's suspecting that somehow you are having inappropriate interactions with students. And the word boundaries comes to mind. As a new teacher, you have to have your professional boundaries in place from the very beginning. Your students are not your peers. You are now a professional. If you interact with students, even in a high-grade secondary school setting, in a way that many of you interact with your peers, it is going to be much more likely that people are going to have suspicions about your interactions with students. So you must keep those professional boundaries intact at all times. And there are various ways to do that. Number one is you should never give any kind of inappropriate gifts or rewards to students. Now that may run the gamut between, I've had situations where teachers have given students Victoria's Secret gift cards. That's obviously a violation of your professional boundary. Another way that you can get into trouble with this is if you are giving gifts or rewards to one particular student. There's a number of problems with that. Number one is other students know it. They know that you're treating a student differently than you're treating other students in your class. A lot of times if there's a pattern of doing this, people suspect that you may have some kind of inappropriate relationship with a student. What I always tell students is, even if you have students that are difficult in the class, if you're going to give them rewards, you need to give the rewards to all the students. Believe me, even if they're not high achievers in your classroom, they are achieving in some ways that may not be quite as clear to you. Sometimes just by being there and interacting in the classroom, that can be something that's worthwhile as far as a reward goes. So don't single out students to give gifts or rewards. Probably this sounds silly when I put it this way, don't date or have sex with students. Usually, teachers think that's a ridiculous suggestion because they think, well, how would I ever have sex with students? But the answer is, this happens quite a bit. When I say have sex or date, I mean any time you give advice to students, for example, about their romantic life, that crosses a professional boundary. Anytime you make arrangements to meet a student after school, in my book, that's a date. And it's a way that you singled out this student for special treatment that some people might suspect to be romantic in nature. When I say have sex, I mean that in the broadest possible context. Do not ever use sexual innuendo with students, whether texting, emails, in person in the classroom, whatever it happens to be. That is the kind of thing that can lead you down the path where people suspect that you're having an inappropriate sexual relationship with a student. And as we go through these, if you think about it, if you stack these on top of each other, it's even more likely that it may create problems. If you give a gift to a student and then somebody sees you with that student after school, like getting coffee or something, or if they know that you've texted something inappropriate to the student, all these things can build up and it can point the finger directly at you for violating your professional boundaries. Another way teachers can get into trouble is if they play the therapy game, and this quite often happens to younger, less experienced teachers. Students have personal issues that they sometimes will share, They will look up to you as somebody that they can confide in. There is no teacher confidentiality. You cannot promise confidentiality with students. But more often this takes, for example, if a student talks about a romantic relationship and you give the student advice about how to handle a romantic relationship, or you tell them about your vast experiences in your romantic relationships, those are things that can cross the professional boundary. I'm not saying that you shouldn't listen to students when they tell you these things, but what I am saying is don't cross the boundary by basically becoming a parent or a psychotherapist with a student. Finally, touch is very important. Touching students in this day and age is very dangerous activity. People can get the wrong idea. Students can become uncomfortable with physical proximity and with touch. There are many times when you as a teacher are going to have to touch a student. Students can be very upset. The bottom line is on teaching is nurturing of a child, and sometimes touch is certainly appropriate. What I would suggest to you, though, is you need to touch students in a way that is not going to create some kind of a suspicion of an inappropriate relationship, or not touch them in a way that is going to make the student feel uncomfortable. Those are things that can lead you down the path of a suspicion of child abuse. What I would suggest to you is a touch on the point of a shoulder is just as effective as a hug. And if somebody needs nurturing, needs attention, needs understanding, you can connect with a student on a physical level in ways that is not going to put you at risk. Hugs, for example, whether they be half hugs, side-to-side hugs, or full body hugs, are rife with danger for you as a professional, and I would suggest that you never engage in hugging students. If a student wants to hug you, that's different in some respects, but you need to use physical contact in an age-appropriate way. That is, if you're teaching in a first grade classroom with an extraordinary needs child who comes up to you and hugs you around the legs because they like you and they care about you or they need nurturing, that's one thing. When you are a male elementary school teacher and you have a habit of basically taking young female students on your lap during class, that's something that can cause huge problems for you, and you shouldn't do it. Secondary school teachers, you should not be hugging students. It's just too dangerous for you as a professional. Touch with care, only touch when necessary. And in regard to corporal punishment, there is really no such thing in this day and age. You should never react to students physically in anger or even emotionally in anger. However long it takes to calm down, count to 5, count to 10, count to 20, don't ever do anything in anger. You must keep your cool. That is just another kind of professional boundary at all times.
So that's quite a long list around sort of touch in particular. And I guess I want to ask you a little bit if you can help teachers understand what protections they have with regard to using reasonable force and or nurturing touch.
Well, state law and school district policies are required to provide situations in which teachers have the right to use reasonable and appropriate force or nurturing touch. And if that's what a teacher is doing, they can be immune from any kind of criminal prosecution and civil liability unless they're basically touching a student in order to punish them. School districts are required to have policies regarding rules for student discipline, and we touched on those earlier. Most often this comes up in the context, for example, of if you observe students fighting, say in a hallway when you have hall duty, and the teacher is basically required to intervene if necessary. In other words, they have the right to intervene to keep students from harming each other. That's one of the elements under state law and under school district policies. But if intervening with the student and by restraining them briefly to keep them, say for example, from assaulting another student, you have to grip that student hard enough where it may cause a bruise or it may cause redness or something like that. It may cause something that might fall under the definition of child abuse. School employees do have immunity from being charged if those kinds of manifestations of physical harm occur merely while you're doing your job and you're trying to keep students from harming each other.
And I guess relatedly here is understanding, the reverse. We've been talking mostly about teacher touch towards student, but what about teachers' protection from student touch towards teachers? Can you help us understand that?
Quite often, school district administrators will err on the side of the child. That is, we're very concerned with children being harmed in a school setting, but sometimes it can happen to teachers as well. And schools are required under state law to adopt certain policies or procedures in situations where basically a school district employee is themselves assaulted or harassed in some way. When that happens, you as a student teacher or other teachers should report to law enforcement. And there may be some protections in the school district's policy that would afford you some relief in regard to these types of situations. What you shouldn't do is sit back and say, well, the student was having a hard day. I understand where they're coming from. I get that they hit me and now I have a bruise, but I don't want to report them. These are things that are very serious that you should report. Now, the district is required under state law to investigate those types of allegations. And if in fact they think that some type of assault has occurred against a school district employee, they do have some discretion, but usually it results in at least a 3-day suspension for students. If it happens on a habitual basis, then those things should be reported, and the school district will look at potentially expelling that student. I just want to touch on this too. You do have some options if you feel like the school district is not protecting you. If you wanted, for example, to file a petition for a temporary restraining order to keep the student away, I would recommend you only do that in the most serious of situations. Generally speaking, if you're hurt at school, the school district is going to do things to protect you, and they should respond to your complaints, but they can only respond to your complaints if you make them.
All right, so we've sort of wrapped up the touchy issues or sensitive issues around child abuse and touching students, et cetera, and we're going to shift gears now to another equally sensitive issue for all of you, and that's digital expression. And we want to really think about what your responsibilities and what you should be aware of as someone who has a Facebook presence, a Twitter account, material up on YouTube in terms of being a teacher and what responsibilities you have around this. So I'm going to shift that and maybe talk a little bit about some general guidelines or rules around digital expression.
Well, this is probably one of the more serious issues that comes up in this day and age. The facility with which we now communicate, particularly with students in a school setting, can be basically a minefield for young professionals. And so it's important as we go into this that you understand that, again, it's a professional boundary type issue. You may be very used to communicating with your peers digitally through these various mediums, but it is very easy for you as a professional to get in trouble when you do that with students or other employees. Number one, you can, either as a student teacher or as a teacher, be disciplined for when you communicate with students, just like if you said those things in the classroom. If you use sexual innuendo in a text or an email or in a phone call, that's just the same as doing it in the classroom, and you can run into trouble when you communicate in that manner. So it's important for you to remember that. Even more important, and this is the part that I think young professionals don't understand, is you can even be disciplined for things that you do outside of school. If somehow the school can show that what you do outside of school does have an adverse impact on students, the school districts, or your ability to teach. In some respects, some of these rules go back to the Victorian age, where teachers not only were expected to comport themselves professionally in the classroom, but they were expected to also do it in their personal life. And in some respects, we're going back to a situation like that now.
And I think it's important for us to realize that the law over the course of your early years in your career will probably move around in this particular area. But for now, we're advising your sensitivity to the boundaries and to exercise careful attention, because none of us wants to see your early career disrupted by by your social media use, that even if it's far afield from your own student teaching or teaching practice. And we want to point out, for example, the parable of the drunken pirate, which is a case law that guides some of our advice to you at this point in time.
You know, it's very important to us that we give you an example of what we're talking about. I know, for example, that on Facebook sites, quite often there'll be pictures that you may have posted of yourself, or others may have posted of you, that portray you in a negative light. And it's probably no surprise to realize that when those come to the attention of your students or your supervisors, that can cause a serious problem for you. Probably drinking in your private life and then posting pictures like this one it's the most common example of how essentially off-duty conduct can still cause problems for you. This is an actual student teacher, and this is an actual photo on a Facebook site, and she posted this, and unfortunately, they found out about it. And when they did find out about it, they were very upset. She was a student teacher. She was working on her degree in education at Millersville University. The photo that she posted came to the attention of university officials through the school district, through her students. And there were many musings on her Facebook site about her proclivity for the use of alcohol and her partying abilities. And essentially, the university decided that that was inappropriate. It was, in fact, affecting her ability to work as a professional in the school, and so they terminated her student teaching assignment. She filed suit and said, I was just expressing myself. It was a private social media site, had nothing to do with school. And the court said, no, your rights have not been violated. Those things caused a material and significant disruption, not only of your student teaching, but of your work in the school. And the university certainly has the ability to discipline you as a result of that.
So in light of that, what kinds of tips do you have for our candidates and student teachers with regard to their public life?
Well, there's a few things you can do to kind of remove some of the risk of your digital expression causing problems for you in the school. Number one is it's always a bad idea to text or email individual students. If you do have to do so, you need to be very careful with that. What I suggest you do is use a class website, which is accessible to all students so that you can't be accused of singling out a particular student. And then when you receive questions or comments from students about the schoolwork, post those questions to everyone and put your response on the class website to everyone. That way you're completely eliminating the risk of, first of all, saying something that might be misunderstood by someone. You're also eliminating the risk of individual communication or singling out a particular student. I understand in this day and age school districts are saying you have to be available 24/7 to your student, but that does not mean that you can't exercise these basically simple cautionary rules in your interaction with students. Second one, don't social network with students. I know that you become close to students and they will ask to be friended and to befriend you, but it's a bad idea. There are going to be things on your social networking sites that certainly, if your students knew about it, may cause some kind of disruption of the educational environment. This might be even something as innocuous as your relationship status. These are things that they don't have to know. I would suggest even doing it with students that have been out of school for a number of years can cause problems with you. If you initiate an inappropriate relationship with a student who has graduated, the school district is going to look at that and they're going to have suspicions that basically you might be grooming students while they are still students for a relationship later in their life. So it can cause some serious problems with you. If you must social network, make sure that your security settings are clear and students aren't able to reach into your personal life in that way. Similarly, if people post inappropriate pictures of you on their sites, you must now, in this day and age, basically police yourself And if you become aware of them, I would suggest that you ask them to take those things off because we can't be sure of their security settings. So anyway, bottom line is don't social network with students under any circumstances. Don't call individual students on their cell phones. Don't let students use your cell. One brief story I like to tell with this is there was a situation a number of years ago where a student teacher's phone was stolen by a student, and that particular student teacher had some inappropriate photos on their phone that had to do with their relationship with their significant other. The problem being that they were very explicit in nature, and so what happens is after the phone is stolen, I mean, I'm sure you can understand that that would be too good to keep, and so those images were then sent out by the student to all their friends, then their friends sent out the image to all their friends, and pretty soon everybody in the school had these explicit, inappropriate photos. Do not leave your personal cell phone out in a place where students can get it. Keep it buried. Consider not taking it to school. You shouldn't be talking on your cell phone while you're teaching anyway, but if you must take it to school, be sure it's secure.
So help us understand some potential tips for private life since we're in this era where sort of public-private have blurry edges. What might be some advice you have here?
Well, you need to be very careful with posting anything which is sexually suggestive or explicit in any way. That might have to do with artwork, that might have to do with writing, photographs, any kind of messaging. If someone can reach it, and students become aware of it or other teachers become aware of it, it can definitely cause a disruption of the educational system, a material and significant disruption of the learning environment, and you might be disciplined for it. One of the stories I like to tell is the guy in Georgia who was an artist, and he created what he liked to call butt art, which involved basically rolling paint on his front and back sides and then pressing himself up against canvases and building little mosaics that were artistic, and then he sold them online. Well, the problem with that is they were fairly sexually explicit, and his students and his supervisors became aware of it, and he was terminated. The court ultimately found that that was a protected First Amendment activity. However, what I want to point out to you is that you need to be very careful with any kind of sexually suggestive or explicit communication digitally. You need to be very careful with anything you post talking about any kind of sexual relationship, either that you or your friends or your students may have. One of the main things that teachers and student teachers do that gets them into trouble is they'll post comments which are only semi-private about their own drug and alcohol use. That can be a very difficult thing to deal with if your administrator becomes aware of it. I would also point out that it can keep you from getting a teaching job if your prospective employer finds out about it. Finally, it's very important that you compel your friends and others to respect your public image. In some ways, the boundaries in this area are all about your public image. You have to maintain a much more professional public image at this point in your career.
And then finally, can you give us a little bit of advice about what we need to do in terms of using school computers and blogging, et cetera, and being attentive to any ways in which that might affect you as a teacher legally?
This is something that's coming up with more frequency now. School districts have policies about what is appropriate use of school equipment. The first thing I'd like to make sure that you understand is a school computer is just that. It is a school computer. It should not be used as your personal computer. You should not go web surfing on a school computer. A school computer is for two things: communicating about professional topics with your colleagues, getting information from your colleagues by email, and also about working with student activities, curriculum, classroom activities, whatever it happens to be. Anything outside of that is imprudent. You should not be surfing the web. You should not be accessing your personal email on your work computer. You should not be creating things on your school work computer that you wouldn't want you, your friends, and your mother to see. anything you place on your work computer that doesn't have to do with work should be strictly limited. Another problem that sometimes comes up, particularly in this age of protection of student records and things like that, and testing. If you're doing personal blogs about your experience as an educator and you're posting those things, sometimes that may be a violation of federal law if you're talking about particular students. I know for a fact that the Colorado Department of Education takes a very dim view of editorial comments from teachers in regard to the administration of required state tests. These are ways for you to basically cross the boundaries, cross the professional boundaries in a way that may cause you problems with your employment and your future career.
So on this happy note, we are actually concluding our presentation, our conversation, and I think the summary point around some of the teacher issues that we want to make sure you are apprised of is to really understand the boundaries and that there's a lot of gray area out there for you as a beginning teacher to be attentive to. And our hope in this presentation was to raise awareness and for you to follow up with Jenny Whitcomb if you have specific questions, and or you can ask your building administrators and or individuals in your school district to help you understand how a particular issue may play out in your school district. We hope that this particular information helps you go into your student teaching experience with a little bit more knowledge about some legal issues and responsibilities that you have as a teacher to protect your children's safety and your own well-being and public image. And we really hope that you have an extremely successful student teaching semester. Thank you again. And thank you, Brad, very much for making time to help us understand some of these big issues.
Thank you.